Everything that is explained in this video is summarized from CoinMarketCap. And also, please don't forget to support my channel for more XRP updates and some other cryptocurrencies as a whole. Now, take a look at this. XRP sees green amid CC legal tussle. Ripple's response awaited. In the ongoing legal struggle between the United States Securities and Exchange Commission (SIT) and Ripple Labs, which is highly significant for the cryptocurrency industry, there was yet another round of court papers. In response to the motion made by the defendant to exclude fresh expert materials, the Securities and Exchange Commission submitted its opposition within the context of the ongoing legal battle. Ripple's XRP is experiencing a downward trend. The SEC opposes the motion. According to the documents that were submitted to the court, the commission then proceeded to submit an opposition brief in response to Ripple's action to strike. A challenge was made by the defendant to the testimony provided by Andrea Fox, an accountant for the SEC. As far as the watchdog is concerned, Fox's testimony is not considered to be expert testimony because it is considered to be typical summary evidence. In this particular case, the SEC's denial of Ripple's assertion that it had received hidden expert testimony is of utmost significance. Ripple, on the other hand, puts up the argument that the commission has designated Fox as a summary witness. Given this, it appears that it is unable to provide any fresh information. It raises doubts regarding whether or not the discovery requirements are being complied with. The industry is currently anticipating Ripple's response shortly. It is anticipated that the defendants will submit a response to this by the 2nd of May. There is a possibility that the filing would center on the question of whether or not Fox's declaration included any new material or other exhibits. Following the submission made by Ripple, the commission will be accountable for submitting a reply brief by the deadline of May 6 to address the resistance. There is still a significant distance to travel in this complicated case. In its opening brief, the Securities and Exchange Commission (SEC) highlighted the penalties and injunctions placed against Ripple for violating a securities laws. XRP, which is Ripple's native coin, is still struggling to overcome the heightened selling pressure that is present in the cryptocurrency market. In the meantime, XRP experienced a change in its status as it printed a green index on Tuesday, which was the first time it had done so in a considerable amount of time. Over the past 24 hours, the price of XRP has increased by more than 2%. Following the enormous selling that was done by whales and tiny holders, this spike has come about. Taking into account the year-to-date basis, the cryptocurrency is still down by 16. At this moment, the average price of the stock is 5,125 cents, and it is currently trading from its all-time high of $3.84, which was recorded on January 4, 2018. It is currently trading at a price that is 86 lower. On a 24-hour basis, the trading volume of XRP has increased by 18, reaching a total of $997 million. Even though it is facing regulatory difficulties from the most prominent financial watchdog, its market cap currently stands at $28. Recent judicial decisions against Terraform Labs, Duke One, and Coinbase provide additional evidence of the additional regulatory scrutiny that crypto businesses are subjected to. The significance of ongoing legal processes is brought to light by these verdicts, which serve as reminders of the regulatory ambiguity that surrounds cryptocurrencies. In the current legal dispute concerning XRP's legitimacy, Ripple Labs has filed a move to prevent the declaration of a crucial expert witness. However, the Securities and Exchange Commission (SEC) has responded. The crux of the dispute centers on Ripple's contention that Andrea Fox's declaration, dubbed the Fox Declaration, represents an uninvited professional opinion. The SEC disputes this, claiming that the declaration is used for disgorgement computations and is an acceptable summary witness statement under Federal Rule of Evidence 1006. Defensive summary witness used by the SEC, the purpose of the Fox Declaration, which helps the court by using certain portions of Ripple's financial and sales data to compute prejudgment interest over what the SEC refers to as ill-gotten gains, is made clear by the SEC's resistance. The majority of the material in the document is derived from records produced by Ripple, including tax reports and audited financial statements, among others. The CC notes that the declaration is based on math to provide the court with clarity regarding Ripple's accounting, not on an award or the evidence of any specific experts. Acceptability of condensed evidence is part of its case. The SEC adds that Ripple does not dispute the accuracy of the math in the Fox Declaration. Ripple disagrees with the declaration's format and thinks it ought to be regarded as expert testimony. The SEC responds to this claim by citing case law that establishes the inadmissibility of summary evidence as an expert witness. The SEC highlights instances in which the use of accounting techniques of the A declaration was not elevated to the status of an expert opinion by the summary information presented. In addition, the sexy statement notes that while Andrea Fox holds a professional accounting background, her expertise is not applied to Ripple's financial data and the Fox declaration beyond simple math. It maintains that Fox neither made any significant choices about Ripple's financial practices, nor expressed any opinions about how the company accounts for its income and expenses. Rather, her task was to compile copious amounts of data into a more readable format for the court. Previous unsuccessful rejection of Ripple, the SEC further points out that in a different matter involving the statement of another SEC staff accountant, Judge Torres had previously dismissed Ripple's identical objection. This earlier case contends that the present complaints from Ripple should also be rejected. As a result, the SEC guarantees that the federal rules of civil procedure have not been broken. The SEC claims that because the Fox declaration does not fit into any of the categories that call for such pretrial disclosure, it was not required to be disclosed in advance as expert testimony. Thus, the CC argues that the filing of the summary witness declaration should not come as a surprise or do Ripple any harm. The substantial obstacles that the U.S. Securities and Exchange Commission (SEC) would provide to a settlement with Ripple were highlighted by pro-XRP attorney Bill Morgan. The SEC is anticipated to file numerous appeals in the ongoing Ripple v. SEC court dispute to prevent the blockchain payments company from winning. Holding up Ripple versus SEC settlement, Morgan outlined the main challenges as the SEC's attempt to obtain an injunction to stop Ripple's on-demand liquidity, fellow sales, and its intention to challenge programmatic sales in a post on X. Bigger obstacles to settlement are the SEC's intention to appeal on programmatic sales and its request for an injunction to stop odal sales. Morgan said, furthermore, these sexy moves suggest that Ripple and the other parties are continuing their legal battle. As well as the regulatory body, Morgan's comments clarified the intricacies of the ongoing legal dispute and the difficulties that both parties encountered in coming to a settlement. In addition, the CC's efforts to prevent Ripple's victory are predicted to hurt the price of XRP. Furthermore, as outlays are one of the main components, the operations of Ripple and its subsidiaries may be jeopardized. However, proponents of XRP think that the cryptocurrency's value will soar if the Ripple v. Sexy lawsuit, eventually results in a settlement. Morgan concurred, predicting that the XRP price, which is now at $0.5, may reach $1 following the settlement. In addition, the SEC is anticipated to respond to Ripple's move challenging the outrageous fine assessed by the organization. A new scheduling order was issued by Magistrate Judge Sarah Netburn last week to forward the case for remedies and a final judgment. The SEC has submitted new expert submissions, which Ripple is pleading to be dismissed.